If you're a lawful permanent resident, is it possible to get a J-1 waiver? Or what about if your children have special needs? Today we're going to be talking about a case study where we got a case approved with government funding. Yes, government funding. And we were still able to get it approved with a lawful permanent resident, spouse, 2 U.S. citizen children, and a child with special needs. Now, it's really important to note that you have to demonstrate hardship both relocated to the home country or if you were separated. So it's not just one of those standards, it's both. And you have to also prove exceptional hardship to USCIS and the Department of State. So you have 2 government agencies to deal with as well. Let's talk about the processing time so you can get an update on the latest processing times. Here we filed with USCIS and Department of State on November 3rd, 2022. Department of State processed the case on November 17th, 2022. Department of State processed the I-613 from USCIS on February 13th, 2024. And Department of State issued the favorable recommendation on July 25th, 2024. And USCIS approved the case on August 1st, 2024. So here you can see that the case took a little bit less than 2 years to get approved. Now, let's dive into the hardships because that is what makes the case. You have to demonstrate exceptional hardship. It is a very high standard. These cases are very difficult to win, and we're going to talk about how we were able to demonstrate exceptional hardship to our applicant who was from Greece. Now, it's important to remember that you must demonstrate hardship if you're separated or if you're both going to the home country as well. Here, the applicant had 2 U.S. citizen children. One of the U.S. citizen children had special needs. We have a number of cases where our clients have children with special needs. Special needs can involve a variety of different kinds of different hardships. Your child might need an occupational therapist. Your child may have sensory processing. Your child may have autism. Your child might have ADHD. Your child may have some other form of neurodivergency. I'm personally very familiar with the issues that come up with autism because my child has autism, so this is very near and dear to my heart when your child has special needs. Let's talk about this specific situation and the special needs that this client had. The J-1 applicant's daughter had been diagnosed with developmental delays and had below average verbal comprehension. Now, if they had to relocate to Greece, the accommodations were either non-existent or getting accommodations would be highly stigmatized. And this is true for a variety of countries that we work with as well. And we've made this argument in a variety of different scenarios. Now, the child having sensory processing, this is something that many people, even in the United States, don't have an awareness of. And if the daughter was going to go back to Greece, they didn't have an awareness of. So of course it was impossible to treat this when there's such a high lack of awareness of what sensory processing is. And what we're finding is with special needs children is that a lot of new theories are coming to the forefront, and the US is on the cutting edge of these theories where other countries still see special needs as a stigma and don't have the ability to treat special needs. In the US, the child was offered specialized education and therapies essential for her growth, which were not accessible in Greece. Also, I like to include IEPs. If you have an IEP, that's also very helpful to demonstrate that this is documented. Also, we like to talk about the different therapies that your child may be receiving. For instance, if your child is seeing occupational therapy, documentation of that, letter from the occupational therapist. Not only did our clients have this issue, but they also had the issue of financial hardship. The family was already sending financial support to relatives in Greece who were struggling to meet basic necessities. Relocating would have had to put an even greater strain on their resources. The J-1 applicant's spouse is a legal permanent resident and is an engineer. If he would have to go to Greece, he would have jeopardized his career and also his legal status because as a lawful permanent resident, you're supposed to maintain your residency in the United States. If you leave the United States for more than a year, in this situation it would be 2 years, the J-1 applicant's spouse could lose their green card. In this case, we also talked about medical issues. The spouse had ongoing medical issues, including high cholesterol and a family history of heart failure requiring continuous care. Now, not only this, but the spouse had known his partner since childhood. His health risked significantly if they were separated. The J-1 applicant was not only the primary caregiver to their children, but also played a critical role in her spouse's health management, from meal planning to ensuring he followed his exercise routine. Without her presence, the family would have been left in a precarious situation, unable to maintain the emotional, physical, and financial stability that they relied on. Following the J-1 waiver success, we were also retained to file for the green card, so we were honored to continue with the green card process. We are so grateful that we were able to help make a difference so the clients could stay together and not face all of these exceptional hardships if they had to go back to Greece. I hope this video served you. Make sure you subscribe so you continue to get updates, and by watching this video, you're bettering yourself. By bettering yourself, you're bettering your family, and by bettering your family, you're bettering the world. Bye for now.